Yes, sir.
My lord, page 11 is Kerala State Welfare Corporation for Forwarded Communities. So other side is alleging that this is first time government of India did something. No, this was there. And my lord, page.
Your time is getting over.
My lord, 2 minutes. 2 minutes. My lord, no, this is how to explain.
Just now, next 3 minutes, and
yeah,
we'll
very
call upon the other.
Page 12, my lord. My lord, Chief Justice asked me a question that what is the after effect of this amendment. My lord, may kindly see before 103rd amendment and before increase of seats. Well, it's extremely important according to me. My submission is this after this table that you are also benefiting in addition to what you are having. Because of why? It is increasing 10% seats and appointments, etc. So, what is you are getting before the amendment? My lord, row 2, SC, 15%, and total available pool quota. A plus D. Well, C, D is open category. Okay. SC plus open category is for SC 65%. Got it? Now ST. B plus D. That is open quota plus ST 58%.
Yes.
Now, my lords, C 27 OBC. C plus D is 77.5%. They can claim only this. SC cannot come to the compartment of ST. So therefore, this is what before the amendment. Now my lords, my explanation is there. Now my lords may come what will happen after the amendment. This is what my lord was asking to me. My lord, SC 15%, A plus D, total available quota. A plus D, D is open category 55.5%. B, 7.5% plus D, 48%.
Correct, sir. Less than 10. Less.
Now, my lord, how it will to be understood, next is very important, my lord. Suppose total 100 seats are there. Sorry, 1,000 seats are there. That is what important.
That is, Mr. Bijou.
Page 13.
On this, it is true that what you have put in tabular chart is the scenario.
Yes.
Nobody is disputing that. Correct. That's the effect of the amendment.
No, my lord. I'm sorry to say, my lord, with utmost respect to my lords, but my lords repeatedly asked a particular question, and they also argued one thing that we are losing something. How it is affecting to SC, ST, OBC, whether something is going from their pocket. So here, my lords, last row 4, 1,100 now. From 1,000, it became 1,100 members.
Correct.
Then SC is getting 165 seats instead of 150, 10% increase. To them also. Then, my lords, ST also.
So therefore, the moment you increase the seats, naturally it gets cushioned. Correct. What your submission is that after the effect of the amendment and increase, the seats are reserved. Then there will be equality at the level where it was prior to the amendment and post the amendment.
Yes, and they are actually benefited in addition.
It may have happened in a particular fact situation, so therefore we'll note that. Any other submission, Mr. Bijou?
My lords, now come to page 14. My lords, page 15.
And I have already taken 10 minutes.
Yes, I finished, my lord.
Therefore, yes.
My lords, page 14 to 16 says that government also decided to increase the seats and appointments and their.
Yes.
And this is what my submission, my lords. Ultimately, my lords, again, I may submit that, my lords, this is not a case of affected their fundamental rights. Writ to jurisdiction 32, I request my lords, with utmost respect, my lords, I filed so many petitions, Devadasi case, Trado case, so many. I was getting a call from the registry that this has not been followed, this guidelines has not been followed. I don't know how this 55 writ petition numbered, what is their prayer, etc.
Mr. Bijou, argue on merits, sir. Correct?
Yes. No, my lord, not followed the guidelines. That's it, my lord. So therefore, my lord, ultimately my submission is that, my lords, the Sindhu Commission, adequate representation, and these poor people, and accordingly they have to get some kind of accommodation according to the Constitution and fundamental rights. My lord, their rights may be protected. With utmost respect, my lord, I'm grateful, my lord.
Thank you.
Thank you. Patiently.
Thank you.
Grateful.
Can I have only 5 minutes?
Yes.
Some development, there's something which has come to my notice, that
Yes.
I am duty bound, but I undertake to place this in e-copy format as well as the bound format. It's only 1 page. Therefore, my lord, right now not in a bound format. Because as my lord, I have indicated that the government as a sovereign is responding to the wishes and aspirations of.
My lord, I am going to another.
Oh, yes.
Aspirations of several, my lord, and this is what, my lord, we have tried. Para 3, my lord, 1 and 2, your lordships can ignore. It is submitted that contemporaneously with the constitutional amendment, a decision was taken in order to ensure that the seats available to the reserved category and the open category are not impacted in absolute numbers the Department of Higher Education issued orders on 17 January 2019 to all central educational institutions to increase the intake in all branches of study to provide 10% reservation to economically weaker section while protecting the proportionate reservations for scheduled caste, scheduled tribe, and other backward classes, and also not reducing the seat availability in the general category in absolute numbers in the year 2018-19. It is submitted that as per the calculations done in this regard, in order to provide 10% reservation for the economically weaker sections without adversely impacting the proportionate representation reservations to the SC, ST, and OBC categories, and not reducing the seat availability for the general category in absolute numbers as compared to admissions made in 2018-19, the total increase in intake has to be increased by approximately 25% over and above the intake in 18-19. It is submitted that a total of 2,14,766 additional seats were approved to be created in the central educational institutions, and an expenditure of rupees 4,315 crore was approved to be incurred to improve the infrastructure in the higher educational institutions. This is proportionate, but saying.
Solicitor, correspondingly, I would like you, not right now, to give the data over a period, maybe.
Your Lordship's claim.
Yes, give the data about the number of scholarships available to all people. Number of scholarships. There is a scholarships portal. What I have been able to get is a very limited. What is the kind of scholarship that you give for medical, engineering, and other professional courses, which are the subject of these central universities? The quantum of these per capita, scholarships, because they are looking at people, whether it's this or that, doesn't matter. The poorest of the poor in all categories, ultimately, when they get in, what is the fee that they pay? What is the aid that the government gives? Because that is an important component also of affirmative action.
But since it has fallen from your Lordships, it's my duty to, my Lord, provide that detail. So I very emphatically would respectfully submit that those figures and statistics would be relevant for the Parliament to take a decision whether to provide for this or not.
No, you're
It
right.
may not have any
No.
impact on the constitutionality.
No, you're right. We want to know. For instance, the National Scholarships Portal says that for a higher education, 82,000 scholarships are given throughout the country on economic basis. And there's a separate one for SC, ST. And well, I will not get a substantial amount is given, which is about 10 or 12,000 a year. Now, similarly for professional colleges or management colleges, what is the figure for even these EWS people to ultimately you're talking of the poorest of the poor, or just marginally about that?
Poorest of the poor who are otherwise not getting any reservation benefit.
No,
Number
who are getting scholarships. So I just want to know.
I will not, it has fallen from your Lordships, it's our duty, we shall place.
Yes.
But that since they are getting benefit, why give them reservation?
No,
Maybe
please.
a policy issue, not a constitutionality issue. That's all.
Mr. Solicitor, we are aware of what we are looking at.
No, your Lordships are aware, more than aware, my Lords. Even, my Lord, even this affidavit, my Lord, absent this affidavit, it would not mean that the constitutional amendment fails. And with this affidavit, it would not mean that constitutional amendment is constitutionally valid. This is for to satisfy your Lordship's conscience. If, my Lord, there is some doubt that this might have an impact on the general candidates who are otherwise meritorious. And if your Lordships have any doubt that these are three silos, three separate zones, and if your Lordships were to take a view that poorest of the poor, even in the first reserve category, should be shifted, the economically weaker section, 10% should go there, it would result in two things. A, double reservation in the first category, and B, it would substantially amount to amending the constitution beyond the intent of the legislature.
Very well. Thank you, sir.
And scholarship would also be merit-based as well as, my Lord, need-based. I, my Lord, subject to the verification.
Sure.
And last request, my Lord, learned AG wanted to place a note. My learned AG has not placed any note. My Lord, which we will file it by tomorrow. My Lord, he is in the process of preparation. I'm seeking my Lord's leave. It would be your Lordship's question and Lord, possible answers on behalf of the government on constitutional. Lord, I'm grateful.
Thank you. Yes, Mr. Ravin. Yes, please. 5 minutes by the clock, sir. So, please. Yeah.
benefit very simple classification because we can identify or distinguish the person the beneficiary belonging to economically weaker section and the family he belongs to. And this reasonable classification has been in existence for the benefit of people since long, and it goes from Article 14. So, on that aspect, this constitution. Now, regarding the matter of reaching the 50% barrier, my very humble submission is that the enabling provisions of the Constitution cannot contradict or override the mandate of a fundamental right. The legislations constituent 15.4 and 16.4 are class legislations, and they are forbidden by Article 14. They are not in keeping with Article 14. So, to my mind, they are untenable. So, considering them for 50% reservation is untenable. So, I believe there is not peace. That's my submission, madam. On the issue of 10% fees being awarded and not being given to 16.4 categories, they have a place of reservation. Those candidates from the reserve category have two arenas. One is their arena, the reserve one, and one is the general category arena. They have two places, but the general category person has only one place. So he has been given provision in 10% of that. Now, when this OBC reservation came up, the right of the SC/ST people in the general category was also taken away in that sense. It was held constitutional then. It is, I believe, constitutional now. That's all, man. Thank you.
Thank you. Thank you. Yes, Mr. Ravi Kumar. Mr. Ravi Kumar, who is going to follow you? Dr. Mohan Gopal, then
Mr. William, and I'll follow Ravi. And then Professor Mohan Gopal.
Because I fall in the middle, the petitioners could possibly respond to me as well, was my suggestion.
okay, very good.
Whichever
We
way.
all stand in one group. I see a council will address your order.
Very good.
No, in fact, after the court allotted limited number of hours, all the council appearing on this side, we have put our heads together and
Need some internal allocation.
yeah, some arrangement.
So we all will fall in one group. Gopal will be in another group.
Yeah,
Very good.
we'll proceed as per the consensus.
Sure, sure, yes. Great, sir.
Sir, I request the court to kindly recollect the disaster of 2005 tsunami on this country. Lakhs of people perished and millions of people were uprooted. So the Indian Navy undertook an exercise to save the persons who were in trouble. So they went around the entire coastal area. In particular, we want to refer to this. Andaman and Nicobar Islands are devastated. And when the Indian Navy went to Andaman, they could find survivors, they rescued them, and they were able to do something. Very yeoman service was rendered by it. But when they went to Nicobar Islands, they did not find a single soul on those islands. So they declared that the Nicobaris have perished. It was a very dwindling population. So they declared. But again, they continued this search. And when, after 4 or 5 days, when they went to Nicobar Islands, to their pleasant surprise, they discovered not a single Nicobari was touched by tsunami. Then inquiries were made. Researchers came to find out how this miracle could happen. Then it so happened. The tribes of Nicobar, they live in such perfect harmony with nature. They could read the minds of the flora and fauna on Nicobar Islands. And when the monkeys started climbing up the hill, all of them climbed up and sat on a very high tree or took shelter somewhere on top of the mountain. Not a single Nicobar tribesman was killed. Why I'm saying this is, they are the most primitive tribes. In India, the tribes and the scheduled tribes particularly, they're essentially classified as scheduled tribes because of their habitat. They live in such far-off places, not touched by civilization. And more importantly, almost all of them, they do not belong to the main race of Caucasians to which the mainland Indians belong. Now, all these races are eliminated. Nicobaris are eliminated, and all the tribes of Assam are eliminated because they are scheduled tribes. I may just give a short this thing. I've given. I've given a short note, giving a sample survey of some of the tribes from their racial background. Kindly come to para 1.1 at page 3.
Yes.
Before I read that, may I request the court to kindly permit me to show who are scheduled castes and who are scheduled tribes. The definition clause may kindly be used. Article 366.
That which is declared under 341 and 343.
I respectfully agree. But who are declared? What is important for us is who are the people who are so declared? Kindly come to 341. I got on to this observation. Kindly come to Article 341 straight away.
For the purposes of this constitution in relation to each state.
Yes.
Yes. 341 says the president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the caste, kindly mark, the caste, races, or tribes, or parts of or groups within caste, races, or tribes, which shall, for the purposes of the Constitution, be deemed to be scheduled caste in relation to that state or union territory, as the case may be. So the entire list of scheduled castes and the entire list of scheduled tribes are either castes or tribes. Whatever confusion that prevailed among the OBCs, that I'll come to it later. But now consider this. In fact, crux of this matter is a question posed by Honorable Mr. Justice Bhatt on the earlier occasion. What if two words are deleted from 15 and 16, namely gender and caste? Would it not affect the basic structure? If I may say so with respect, that is the crux of the matter. So I've given the details of the races to which the scheduled tribes belong. They are not Caucasians. Mainland Indians are all Caucasians. And all of them, what may kindly take note of it, eloquent submissions are made on a casteless society. Sir, all these tribes are casteless. Why did they stay away from the mainland? Because they did not accept the caste system. That was one of the major reasons. They are very autonomous societies. They live on their own. They never subject themselves to be subordinates or superiors to anybody. And therefore, they remained outside the society. They went to the hills, they went to the forests, and that is where they are living. All of them, they belong to this race. And briefly, I may give the names of certain races. For example, the Northeast tribes, Northeast belong to Mongolian race. Tribes like Khasi, Garo, Dankya, Gelon, Minya, Anagamis, Chesalon, etc. And the central tribes, what is very familiar with these tribes, Gonds, Mundas, Santals, Marias, Beals, they belong to Astric race. And the South Indian tribes, like Vetakuruvas, Jainakuruvas, Soligas, Irulas, Kudias, Iligas, Pondas, Todas, Kotas. They are from a Dravidian or Negroid or Astric racial features. So just keeping this in mind, kindly permit me to read the prohibition against discrimination under Article 15.1.
Yes, sir.
The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of it. All these tribes have been eliminated from 15(6) and 16(6) only because of their race. No other factor. Are they not entitled to the benefit of anything that is done in the name of poor? Can they be eliminated? As Justice Bhatt was pleased to ask, can the words sex and caste be deleted from 15(1) for any program? Would it not offend the basic structure? Sir, I fall back upon the impact test. Please lift the veil of this provision. Put on the glasses to see who are the affected parties who are eliminated from 15(6) and 16(6). Are they not castes and tribes? Therefore, my very respectful submission is that question of Honorable Mr. Justice Bhatt is the crux of the matter, and it is a clear indication that these two provisions have destroyed the equality code by allowing race and sex to be grounds of discrimination. Supposing a similar provision had been made saying that all positions in the Indian Navy or IAS are reserved for men, not for women, because women already have some benefits in 15(3). Would it be sustainable? Would it not offend the basic structure? If I may say so, in that permanent commission case, this Honorable Court has already declared as invalid any such elimination from being considered for permanent commission in the Indian Navy. So if that is true so far as sex is concerned, in my very respectful position, even a constitutional provision which eliminates these races, castes, and tribes also hits the basic structure, alters the identity of the constitution. So both impact test and identity test are answered in the affirmative if we lift the veil of these so-called economically weaker sections to find out who are eliminated. I'll not trouble the court. Enough is said about who are EWS. But who are eliminated, that is very crucial. So I therefore very respectfully submit that this answers the test, both impact test as well as the identity test. Because the equality code is turned upside down by enabling discrimination on the basis of race, on the basis of caste, on the basis of tribes. Article 341 and 342 are sufficient to demonstrate. 341 may not be a fundamental right, but it is a basic feature of the Constitution. And Article 46, I'll be giving the list. I'm glad Honorable Mr. Justice, but just now inquired, what are the scholarships that are given? I have, in my own way, compiled a list. I'll place it before the court. In 5 minutes, I'll be placing it before the court. So it is not an official list, but it comprehensively enlists all the welfare measures that are taken in the country and in some states also. And I request the court to kindly mark that in not a single case are the scheduled castes, scheduled tribes eliminated. There may be special provisions for them, but in the general welfare provisions, scheduled castes and scheduled tribes are not eliminated, not disqualified. They are eligible to apply, they are eligible to compete, and they are eligible to be given admission or given appointment. It is only under 15(6) and 16(6) that they will not be entitled to either apply or compete for the post or take any such benefit under 15(6) and 16(6).
Yes, sir.
Then one of the substantial arguments in defense of the EWS quota is that SC/STs backward classes are given for, sorry, before I kindly permit me to show, the backward classes also, they constitute a collection of castes and tribes. That this Honorable Court has declared in a 13-judge decision in Indrathani. I'll give the paragraph. Paragraph 779, 780, 781, and 782 mechanically.
782.
780. In fact, the whole discussion from paragraph 7562 to 779 relates to whether castes can be included, and para 781, court says you start with the castes. So castes are included, and what are now included are only castes as of now. There is no further classification which is permissible under this. So this may kindly be taken note of. Say that, so not only scheduled castes and scheduled tribes, the entire human sea of eliminated persons for benefits under 15(6) and 16(6) are nothing but races, castes, and tribes, and they could not have been eliminated or discriminated under the provision. That is the bedrock of the equality code. Then kindly come to para 1.2. This submission I have made, I only given a graphic description as to what happened in Champakam Dore Raja. Kindly come to para 1.2 at page 4. Sir, 14 posts were distributed under 3 categories to 3 different communities on the basis of religion. Hindus were given 12, Muslims were given 1, Anglo-Indians and Christians were given 1. Among the Hindus, Brahmins got 2, backward Hindus got 2, Harijans got 2, non-Brahmins got 6. So this was what was the position under the GO, which was popularly called as communal GO, which was struck down in 2 landmark decisions in Venkatramana for services and Champakam Dore Rajan for admissions to educational institutions. Now kindly come to the next statement, 1.2.2. Now what this amendment has done is a very, to put it simply, either applying the impact test, this is what has happened. 100 posts are divided into 5 categories. Scheduled castes, 15 posts. Scheduled tribes, 7.5 posts. Other backward classes, 27 posts. And economically weaker sections, 10. Now kindly stop for a minute before proceeding to the other 40 seats or posts. So what are these 60 posts going to be? They are going to be distributed strictly according with the communal GO, namely 15(6) and 16(6). 15(6) and 16(6) have converted the entire policy of reservation into what earlier was known as communal GO. 40% may be available, but that by itself will not, as this Honorable Court has repeatedly said, honor the doctrine of equal opportunities. So 60% of the posts to be divided, 50% was already divided in accordance with the Constitution as it stood prior to this amendment. And now the remaining 50% seats are subdivided into 10 and 40, while 10 go exclusively on the basis of. So in my very respectful submission, this is hit by the law declared by this Honorable Court in a 7-judge bench decision in Champakam and Venkatramana. So for this reason also, this needs to be struck down as ultra vires Article 368. Then court may kindly recollect, till this point of time, neither the learned Attorney General nor the other counsel who have addressed have provided as to what is the nexus between reservation and poverty. Why should reservation be given? Why not other measures?
Yes.
There appears to be some obsession that reservation is the only panacea for all ills, poverty, hunger, starvation of screaming millions. That was what was said. Sir, what has that got to do for IAS posts being reserved for them? Starving millions? IPS posts being reserved to them? IIM seats, IIT seats, institutes of higher learning. This is what is popularly known as reverse discrimination. Being obsessed with the concept of reservation, they want to extend reservation to everyone, whether or not that is needed. This has been held to be an unconstitutional exercise. In Ajit Singh 2, the Constitution bench, sorry, at para 37, kindly, I'll not trouble the court with the text of the judgment. Kindly come to para 1.8. At page 10. Page 10.
Yes.
This honorable court has said, page 37, para 37, bottom of the page.
Yes, sir.
Kindly come to the bottom of the page. This is
Yes.
also a constitution bench judgment. Thus, this court has to ensure that in matters relating to affirmative action by the state, the rights under Articles 14 and 16 of the individuals to equality of opportunity are not affected. A reasonable balance has to be struck so that, kindly mark these words, affirmative action does not lead to reverse discrimination. In another case, another constitution bench judgment, of course, it is a, I think, dissenting opinion, but the words used may kindly be appreciated. It says, such decisions should not and does not imply that any undue accent on qualifications, the administration can cut back on the larger interest of equalitarianism or may hijack the founding and fighting faith of social justice into the enemy camp of intellectual domination by an elite. The court in extreme cases has to be sentinel on field. This is what has been said. So having said this, my very submission is the impugned amendment deserves to be struck down. Only clarifications which my learned friend, the Attorney General, made a very emphatic submission. Kindly, please. Please. He said, scheduled castes, it is a homogeneous class. Scheduled tribes, it is a homogeneous class. Backward classes, it is again a homogeneous class. Now, with due respects to the learned Attorney General, now this issue is already settled. So far as OBCs are concerned, Indrasani has permitted categorization. Now, on almost all the states, there is categorization. Of course, central OBC list categorization has not yet happened. But in other states, most of the states, in Karnataka, for example, we have 5 categories among the backward classes. So categorization. So it is not a homogeneous class. That's what I would like to emphasize. And so far as the scheduled castes are concerned, court may kindly recollect, as early as in 1965, a committee was appointed by Government of India to go into the working conditions and the problems of scheduled castes and scheduled. They recognize the fact that this is not a homogeneous group and therefore deserves to be differentially treated. That has not happened. Be that as it may, in the latest case of Devendra Singh, 2022 SCC, page 1, 2020. Okay.
The issue has been referred to.
Yes.
7 judges.
So therefore, should the issue of SC/STs being homogeneous and therefore they cannot be subdivided into poorer sections and not poorer sections, that issue, with due respects, it is a matter which is pending before a larger bench of 7 judges. And therefore, that argument may not be available. Even among
Just 1 minute. Just.
para 27 of Devendra Singh has declared that creamy layer may be eliminated from scheduled castes. And about subclassification, the entire case law is reviewed. In particular, Indrasani is followed, Jarnail Singh is referred to, and then the court says that subclassification is permissible. Paragraphs 35, 42, 44 to 48, 51 and 58. In express words, this on what a constitution bench has declared that it is not a homogeneous class.
That's a referral order.
It is a referral order. I respectfully
Therefore,
agree.
it's not
But
something which is a
opinion
final
has been
determination
expressed.
or
Opinion has been expressed as
Opinion.
to why Chinnaya, which declared
Correct,
as
correct.
homogeneous, a bench of coordinate strength has expressed that judgment is incorrect. That is what I want to say. And I'll not read the judgment because my learned friends are eagerly waiting for my conclusion. One last submission before I conclude. One of the justifications given is that EWS classification has already been upheld under the Right to Education Act. I request the court to kindly note, kindly permit me to show from Article 21A.
Yes.
right to education. Under Article 13, any law that infringes fundamental rights will be hit by Article 13 and it will be invalid. But kindly give a close perusal of right to education 21. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Sir, this is a very incongruous provision, if I may say so with respect, which would never fit into the doctrine of fundamental rights. Whatever law the state makes is going to be a fundamental right under this, that is declared to be a fundamental.
The extent is limited by that.
Yes. So EWS category is one such thing. But more importantly, kindly take note of the fact that EWS is an inclusive definition. It includes backward classes, it includes scheduled castes and scheduled tribes. Article 45 as it stood before this amendment, kindly appreciate the fact. In the entire constitution, there was only one provision. No, it is no longer there on the 45 has been amended. That this provision required within 10 years.
Just to take it further, the provision in RTE, that Right to Education Act, it defines
Yes, it defines EWS.
inclusive, that is inclusive.
Inclusive.
Which
Inclusive.
is noticed in Pramati.
Yeah, Pramati, yes, I respectfully agree. It has been upheld in Pramati. That's because that it is an inclusive definition, number one. Because SC/STs can never be included from the concept of weaker sections for any purpose whatsoever. And more so, because 21A in its very nature, it gives such a free hand to the state to enact any law which will be considered as a fundamental. And more importantly, this was to achieve the object of Article 45 as it stood prior to amendment, which provided free and compulsory education to all within a period of 10 years. This was the only time-bound program under the Constitution that has now been deleted. So, therefore, my very respectful submission is, Pramati cannot be relied on as an authority to say EWS is. And now I have received the compilations. May I just pass on?
Yes, please.
Sir, one of the questions that was debated was whether Muslims are included in the backward classes. I have given the list of all Muslim communities that are included in the backward classes. That may be found at page 42. All the Muslim sections that are included is at page 42. And the Christians who are included now under 16.4, that list is at page 46. I've also given a tabular statement regarding the number of castes that are subsequently added after the original notification of 10/9/1993 to the list of backward classes. Kindly come back to page 38.
Yes.
Yeah, a tabular statement at page 40 would suffice to say that as on 31/3/2018, 2,513 castes are found in the list of OBCs. Of them, 775 castes are newly added, subsequent to the judgment of Indra Sami. Then to answer the query of Justice Bhatt, I have placed all the welfare measures that are in operation under Government of India schemes. A large number of them relate to, kindly mark it, education, higher education, skill development. So kindly appreciate the fact in not a single scheme the scheduled castes and scheduled tribes are involved. So welfare concept necessarily includes.
In fact, they are given special scholarships also.
They are given greater incentives. They are Even
One could be specially for the community based and one could be based on.
general,
EWS.
all general schemes. I've given the list of general schemes.
Emphasis is wherever EWS, they have always been included.
Yes, I respect clearly. So with these submissions, I thank the court for this patient hearing. Sir, this is for the first time case involving 100% of the population comes up. When reservations in favor of scheduled caste came, it was only scheduled castes who were affected. Scheduled tribes came, only 7.5% were affected. Or the general category came, only about 15% were the affected parties, and they came before. So the first time, this court is called upon to address an issue which will affect every Indian in the country. I therefore, while thanking the court for expedited hearing, call upon this court to rise to be judicial statesman to strike down this amendment as violating this. Great.
Manoj, I want to briefly respond to the AG and SG submissions with reference to the 50%. That's limited the arguments are going to be. I won't take long. Just if I can quickly take your lordships to 2 or 3 aspects of it. The first, Manoj, is this, that I think I was perhaps misunderstood, both by the respondents and I'm afraid the bench, if I was understood to say that Muslims and Christians are not included in the OBCs at all. What I was saying was simply this, that the argument that had been taken thus far was that as a consequence of this amendment, what happens is that you are providing this reservation only for forward castes. I was saying no, in that EWS, you will find, apart from Hindus, you will find Muslims and Christians. Significantly, we have Muslims and Christians in the OBCs. That compilation I've given your lordship will show your lordships that. But we don't have them in the SCs and STs. In the SCs, we don't. And that's why both the 2 commissions which I mentioned earlier, I have in that small compilation I've just handed up. Just give this. I've put the terms of reference of the Sachar committee as well as the terms of reference. And there is a summary. I must say that these committee reports have not been accepted formally by the government. In fact, on Thursday, Mr. Tahir Mahmood, writing in the Hindustan Times, said he is the only living surviving member of the Ranganath Mishra committee, and he wanted to set right the record that appeared to be there, that the Ranganath Mishra committee's report had been rejected by the government. He said it's not been rejected, but there are recommendations of ours with reference to all minorities. The earlier Sachar committee report was specifically dealing with Muslims. If your lordship will just come in this compilation for a minute to page number 7, there's a summary there. There's a summary by PRS legislative. And just quickly, this gives the summary of the entire Sachar committee report, which shows light of the Muslim minorities. Specifically at page 8, if your lordships can come, to table 6. Salaried workers employed in government, public and large private sectors. All Hindus, your lordships will find, which is broken up into SC, ST, OBC, upper caste. The SC, STs is 30.4 and public private is 12.8. Muslims is 23.7 and 6.5. These are the numbers here. And if your lordship comes to page 9, right side column, second last paragraph, poverty, consumption and standards of living.
Which table?
Page 9, right side column, the second last para, there's a heading which says poverty, consumption and standards of living. Muslims face fairly high levels of poverty. Their conditions on the whole are only slightly better than those of SC/STs, though slightly worse in urban areas. According to NSSO data, overall